So thank you everyone for joining us today. This is actually the kickoff of our Lawyers Doing Cool Things series at the law school. This is a series where we talk to folks who are doing interesting things with their JD degrees, even in business and beyond in the arts. And we focus on individuals who are really moving the dial on important issues. And I think today is a perfect example of that. With the guests that we have here, we have Mondex Corporation's James Palmer. Maybe you can wave a little bit. Waldemar de Boer, Dr. Axel Hagedorn, Michael Hecker and Geri Krauss. Please correct me if I've said anything incorrect there, for an in-depth discussion on restitution law, the restitution process, and the groundbreaking Lewenstein case. And so many of you might have read about the case, a little bit of a summary in the Eventbrite page. I think that our speakers are going to speak to the details of the case today also. Just a very quick introduction to our panelists. I think I left out Camila Borgi as well, who is here. She has an MBA, that is her educational background, and she is a multilingual corporate strategist and business development specialist who has lived and worked throughout Europe, Russia, North America, and Asia. In 2004, she became president of Mondex Corporation. And she actually began her career in art restitution in 1996 as a forensic genealogist. She is an active Toronto business community member and serves on a number of boards, as well as in advisory roles to nonprofit organizations. James Palmer, I'll just say a few words about James. He also has an MBA background, was born in Toronto and established Mondex in 1993, really driven to do work of meaning. And it was important to ensure that Mondex was in a position to help families who had lost their property. And in 1998, I believe, around there, he worked to develop Mondex's expertise to include the restitution of looted art and other cultural property. He speaks regularly in the media and has spoken at a number of seminars. Waldemar, here in the middle, is an art historian who specializes in provenance research. He has a master's and a PhD, I believe, in art history, and he works closely with Mondex's team of provenance researchers to resolve several complex and challenging looted art cases. Dr. Axel Hagedorn on this screen here is legal advisor to Mondex Corporation and practices international business law. I believe he was admitted to both the Hamburg bar in Germany and also Amsterdam as a Dutch lawyer. And then Michael Hecker, who is also on the screen here, is also has a legal background. He completed his legal studies in Germany as well as in Geneva, Switzerland, and was employed by, I have very complex names of what I believe are German ministries here. I won't try to say them, but I believe he was employed by a couple of German ministries as well as the Free State of Bavaria. He's worked advising international media companies and in the insurance sector, as well as in the field of M&A. And he's focused a great deal of his work over the last decade in the field of Nazi looted art and continues his important work in this sector. And then Geri Krauss, also on the screen there, practices as both an advocate and a neutral, working with companies, executives, partners, employees, and individuals. And she works with her clients to find the best strategy to achieve the client-specific goals, taking into account not only legal issues, but also helping navigate emotional barriers that can underlie and complicate legal situations, particularly when the issues involve business breakups. So we're very honored to have them join us today, and I'll turn the stage over to James. Thank you.
Thank you, Teresa. Thank you. Yeah, so Teresa said a few points that I wanted to convey, but basically our most interesting work began with the Washington Declaration in 1998, and that was a declaration which is termed as soft law, established in 1998, which was ratified by about 44 countries to facilitate restitution of looted property that had been looted during the Holocaust. So we started then, and we didn't realize how challenging it was going to be, but it took us about 13 years to do our first restitution. Fortunately, we were learning during the process, so the next restitution took about 2 years, and the third restitution took about a year. And we've been getting better and stronger and learning along the way. Thanks to our amazing team, many of who are here today. Yeah, it's been a great journey, and it continues. We have a lot of challenges, as you can imagine. The challenges are not just legal. There are many different kinds of challenges that we face. For example, if we're dealing with a case, we need to be sensitive to the culture, not just the legal framework of another country. And then if we're dealing with a case that deals in multiple jurisdictions, it raises the complexity, but raises the opportunities. So I will hand you over now to my colleague, Camilla Gordy, and she can explain more.
Yes, I will go back to 1998. Right now, I think there is no doubt that Mondex is the global leader in the area of art restitution. However, in 1998, when we were contemplating exploring the area of art restitution, we were a little bit naive, thinking that the skills and expertise that we've already had in the area of asset recovery in other areas would be easily transferred to this area without realizing how complex these the issues of art restitutions, especially the art restitution of the Nazi era, can be, for a few reasons. One of them, what James touched upon, is multiple jurisdiction that we have to deal in any given case, and also historical law that has to be applied often to these cases, and complexity of provenance research, which I'm sure Waldemar will address, and also complexity of family history, the delicate nature of these cases, and often they're also compounded by unwillingness of possessors to return these despoiled paintings. So although now we are experts, it still often takes us many years and thousands of hours to complete such cases successfully. Thankfully, thanks to the experts in our team and our perseverance, often we are successful. And as we are in the case of Kandinsky paintings, and I will give the floor to Waldemar to tell us more about these cases.
Thank you. So today we are discussing the despoliation of the art collection of the Lewenstein family from Amsterdam, which took place during the Second World War. We will also discuss the recent restitution of two key pieces in their collection by the famous Russian painter Wassily Kandinsky. The paintings which you can see on the screen, Bild mit Häusern, also, or in English, painting with houses, and that's Bunte Leben, which is translated in English, the colorful life. No. See? Slide. Should work.
The IT people disappear.
Just 1 second, please.
Right on the podium.
You can just say next slide also.
Okay, thank you. That makes it easier. So the Lewenstein art collection was largely pieced together by the Dutch Jewish businessman Emanuel Lewenstein, and also his wife Hedwig. Emanuel was the owner of a successful sewing machine company in Amsterdam. Next slide, please. With a head office located at Dam Square, the main square in Amsterdam. Emanuel was passionate about art and collected paintings, drawings, or prints, mostly by contemporary artists. The Lewenstein family bought the two Kandinsky paintings in the 1920s to decorate their family residence in the center of the city of Amsterdam. After Emanuel passed away in 1930, his collection was inherited by his wife Hedwig and was then inherited after her death in 1937 by her children, Robert and Wilhelmina Lewenstein. Next slide, please. But then a lot of things changed for the family when the Nazis invaded the Netherlands in May 1940, which would eventually lead to the death of almost 85% of the Dutch Jewish population. The invasion must have been terrifying for the Lewenstein family and for the company, especially as you can see in the slide to the right, that when the German troops invaded or actually entered Amsterdam after they just had bombed Rotterdam, on the slide to the left, that they practically actually passed by the front door of the Lewenstein company on the same square. Fortunately, at the time for Wilhelmina and Robert, especially for Wilhelmine, she had already left Europe in 1938 to go and live in Mozambique. But Robert was in a more problematic situation because he was living in France. When this country was also invaded by the Nazis in June 1940, he had to escape and left the country, traveling via Spain and then via Portugal to arrive in New York, where he would stay until the end of the war. Well, as a consequence of this Nazi invasion in the Netherlands, Wilhelmine and Robert lost their income from the family company because the company was not allowed to send any money to foreign countries. And that was just the beginning of the family's persecution and spoliation. For instance, in the period between the late 1940 and 1941, the company was taken over by Nazi collaborators. And in 1943, things even got worse. Two aunts and one uncle of Robert and Wilhelmine were murdered in concentration camps. Next slide, please. Yeah.
We have
Next
a
one.
new battery for this.
That's
Should work now. New battery.
Yeah. Now to discuss the fate of their art collection. On October the 9th, 1940, the collection was offered for sale at the most important auction house in Amsterdam at that time, which was called Frederik Muller and Company. Both Kandinsky paintings were offered for sale there as part of an auction of the estate L from Amsterdam. The Lewenstein name was not mentioned in the auction catalog, which came along with this auction, just the letter L. However, our research confirmed that the letter L stands for Lewenstein. No answer has ever been found to the question who had actually brought all these artworks from the Lewenstein collection to this auction in October 1940, nor do we know who received the proceeds of that auction. But nonetheless, considering the circumstances of the sale and the Nazi occupation of the country, the conclusion has been drawn that the sale must have been the result of Nazi persecution. And our attorneys will address this conclusion in more detail during this lecture. The painting Bild mit Häusern was acquired at the auction for only 160 guilders, a fraction of the market value, by David Roel, you can also see in the slide, who at that time was the director of the Stedelijk Museum, or translated in English, the City Museum of Amsterdam. Das Bunte Leben was also sold for an extremely low price, 250 guilders, to the art collector Salomon Slijper. After the auction, Bild mit Häusern was included in the inventory of the Stedelijk Museum, where it would remain until 2022. And Das Bunte Leben remained in Salomon Slijper's possession until his widow, after Slijper's death in 1971, see Salomon Slijper, sold it to the Bayerische Landesbank in Germany, a very large bank in Bavaria. The bank had bought painting on behalf of the Lenbachhaus Museum, a museum in Munich, which is one of the largest collections of Kandinsky paintings in the world. One of the most interesting facts of this case regards the history of the art historian Erika Hamstengel. She was interim director of the Lenbachhaus when the painting was acquired in the 1970s. But during the Second World War, Erika actually had played an active role in assisting the German SS with looting artworks and other assets from Jewish citizens in Italy. But after the war was over, she was surprisingly asked to work for the well-known monuments man, to vice versa help the monuments man rediscover the looted items to the rightful owners. See her here, the Lenbachhaus, you see to the left, and to the right you see Erika Hamstengel working actually with Americans, looking at provenance details of artworks and trying to find out to whom to return them. Erika's dark history was close to forgotten until a restitution claim for Das Bunte Leben was submitted in the US in 2017, in which Erika's story played an important role. Erika's position at the museum in the 1970s helps to explain, considering her Nazi-related past, why the museum at that time of the sale, as far as we know, never made any effort to check whether the painting was looted, even though the name Lewenstein is written on the backside of the painting, as you can see in the slide. And the Lewenstein family could have actually been easily located at the time to discuss the provenance of this artwork. You only see in the slide that the name Lewenstein is slightly misspelled, but you see also in the slide the maiden name of Hedwig Lewenstein, who was called Hedwig Lewenstein Weiermann. So there's no, it was quite clear to whom this painting belonged. After the war, the owners, Robert and Wilhelmine, conducted research about the fate of their art collection. Unfortunately, Robert had passed away in 1974 and Wilhelmine in 2007, before any real progress was made. And everything changed from 2012 onwards, when the heirs of the Lewenstein collection, with help of Mondex Corporation in Toronto, established the whereabouts of the two Kandinsky paintings, as well as the ownership of the Lewenstein family. In late 2012, the Stedelijk Museum received a restitution claim for Bild with Häusern, which was adjudicated by the so-called Dutch Restitution Committee. The committee was established by the Dutch government to help make decisions about restitution of looted art. However, in 2018, after a very long, lengthy process, the Restitution Committee decided that the Stedelijk Museum did not have to restitute the painting to the owners. One of the main reasons to deny restitution was the committee's conclusion that the painting was more important for the museum than the heirs. This decision, in which a balance of interest between the claimants and possessor was applied, received harsh international criticism. Eventually, this painting, as well as Das Bunte Leben, were restituted to the heirs anyway. Now we'll leave it to the various attorneys who worked on this case. So good luck for you to explain this, to explain more about these restitution processes and how we succeeded in the end. Starting with Axel Hagedorn. who was involved in the restitution claim of the artwork in the Netherlands.
Yes, thank you. You can hear me well, I hope.
Yes.
Yeah, so let me start with two personal remarks. First of all, we were under a very extreme time pressure as we were connected and approached by Mondex in October 2019. And there was already a scheduled hearing by the court in December 2019. And as we didn't have any experience with looted art before, it was quite complex to get into this very, very soon and very fast. Second, it was quite, for me, an uneasiness as a German living in the Netherlands to represent Mondex and the Heirs in a case because of looted art from a Jewish family. So, you know, that is, yeah, it's quite surprising, actually. Let me get into the Dutch Restitution Commission. I call them DRC from October 28 on 2018. The first, what I was reading when I got this case, it was this decision. And from the first page, you could immediately feel the way the argumentation was going. It was against the Heirs and everything. You thought, well, why this? You can also go somewhere different. I cannot explain all the things, but I give you some examples. At the end, the main argument was there was a balancing of interests between the Heirs and the museum had more interest because it was a very big part of their collection, a very important painting. With this argumentation, you don't have to restitute anything because you can always say it's very interesting for the museum to keep it. One of the arguments the DRC used was the financial situation of the sewing machine company of the Lewenstein. And they used material and financial data from the years 1935 until 1938, which has, in first instance, needs nothing to say about the situation in 1940. But even more, if a company makes a loss of 100,000 guildens, what was the argument? It doesn't say anything about the financial situation in private. Just let me give you an example. If Elon Musk loses $1 billion in a year, nobody comes to the idea that he might be in financial problems. Furthermore, what was very astonishing, that there was no word in the decision about government regulation, which made it very difficult for Jewish companies to continue their business. And secondly, also was no words about necessity of Jewish families to sell the property to just get some money out of the property and to be able to emigrate. Furthermore, and that was what Waldemar already mentioned, the selling price of 160 euro, as Dutch guildens, was much less than the acquiring price when the Lewenstein bought it in 1923 for 500 guildens. So that already would have been an example for bad faith of the museum to buy it. And another reason there was that there were 100 art items of the Lewensteins at the same auction, and it was by one member of the family who was not acquainted with art auctions. So that must have been also a reason to look at the Stedelijk Museum and the City Museum, why this not is correct. And one important argument is there was a Dutch commission, a committee, the Eckert Committee in 2001. And this committee came to the conclusion that selling after May 10, 1940 had to be treated as forced sales unless there's express evidence to the contrary. And the auction took place on the 8th and 9th of October, so only 1 or 2 days before. And you miss any word about the timing and why this shouldn't be treated as forced sale. If you have such a binding advice, you don't have an appeal. So the only way you can go against such an advice is to go into court. But that is not, that's the only remedy you have. And the problem is that then you have to prove that the advice is unacceptable to standards of reasonableness and fairness. And that is something which already the committee said, the DRC used the same wording. So that's very difficult to get, this annulled. We did some research after the decision, and we came after that and find out that there were 3 members of the DRC who give that binding advice, who had strong ties with the City Museum, and that was quite astonishing, actually, that they never mentioned it. If you have to go against reasonableness and fairness, you always have to take into account the public opinion. Judges are also met by reasonable and fairness by the public opinion. So what we did in the beginning, immediately, we tried all our contacts in respective media, to convince them that our case was much stronger than it appeared from the DRC decision. And I think we did our best and very well, what you see later on. And then it went very fast. Things changed, actually. And there was a big turning point, was an interview in the political program in the night, news called, with Jacob Koonstam. Jacob Koonstam was chairman of a commission that had to review the policy of the DRC. And in this interview, the first thing, or one of the first things he said is that the Netherlands had a AAA status regarding restitution, and which through some 3 decisions of the DRC came into discussion. And one of these 3 decisions he meant we knew it were this Lewenstein case. So he immediately put the pressure on the public opinion too, that there is something going wrong. We had with this commission a meeting in July 2020, and when we were at this commission, we felt immediately that there was a totally different atmosphere. It was much more understanding, more willingness, more mindfulness for the Lewenstein heirs and the case we had. Then on December 1st, 2020, suddenly the chairman of the DRC resigned, and that was quite astonishing because only a few days later it was expected to get the advice from the Koonstam committee about the policy of the DRC. So you could imagine it was quite clear there must have been a big conflict, and that conflict could only be that it was more in our favor than before. And that actually happened. The Koonstam report then followed our argumentation too, and said we have to skip the balancings of interest, which was for us very nice to see. But still, the court case went on. And now what happened then is that only 9 days later, the court decided no restitution. And that is quite astonishing for me. And then I couldn't understand it all. If I would have been a judge at that time, I would have reopened the case. I would have said, parties, there's a new advice, and you should go around the table and discuss it first. And or at least give some argumentation. But they didn't, they just denied it again. So there you can see what the opinion still was against our case. In February 2021, so only 2 months later, the City of Amsterdam, also by media pressure, I'm convinced of that, announces a plea of a new decision by the DRC, and that was quite apparently against the museum. And that was very nice for us. In March, we had to appeal against the case. And luckily, we didn't have to go all the way through, because in August 21, the mayor of Amsterdam decides to restitute the painting, saying priority for correcting injustice has to be fulfilled. And in February 2022, the actual factual restitution took place. So let me make some last remarks. Why did we win? It was the tenacity of Mondex and the Häusern for a long time. I think we had quite convincing legal arguments, and we had important media contacts, which helped us a lot in this way. And at the end, you need also some kind of luck, because the political climate had changed in our favor too. And that our position was correct has been confirmed by the German Restitution Commission, and that can Michael Hecker explain now.
Thank you, Axel.
You're welcome.
Okay, Waldemar, should I start? James? Okay. Thank you very much, Axel. Thank you, Waldemar, for your explanation, which will help to understand what I will tell you within the next 10-15 minutes. In a letter dated November 5th, 2015, the Lewenstein heirs filed a claim for the painting Das Bunte Leben by Wassily Kandinsky. The relationship with Bayerische Landesbank immediately turned out to be very, very difficult. This has remained so till today. One of the main problems is probably that the board of the management of the Bayerische Landesbank did not recognize the political explosiveness of the case. The board of directors transferred the matter to the head of the legal department. The legal department brusquely rejected the claims and stated the legal department had examined the claims in detail. The painting was not looted. The Bayerische Landesbank had acquired the work in good faith from the Jewish collector Slijper from the Netherlands in 1972, which is why the Lewenstein heirs could not be entitled to any rights. The Bayerische Landesbank is not the addressee of the Washington Principles or the... Are you still there?
Yes.
Or the so-called Handreichung. The Handreichung is a kind of instruction manual on how the proceedings before the German Advisory Committee are to be conducted. The Bayerische Landesbank would only agree to proceedings before the Advisory Committee on Nazi-looted art if the decision of the committee were to be binding and if it were to be stipulated that the painting would remain permanently in the Lenbachhaus in Munich. So the maximum the heirs could be achieved would be a plate indicating that the Lewenstein family was the owner of the painting before the war. What Bayerische Landesbank had not expected was that the Lewenstein heirs would file a lawsuit in New York and that they would also write a letter of complaint to the Bavarian state government as the biggest shareholder in the Bayerische Landesbank. Now, all of a sudden, Bayerische Landesbank was prepared to agree to a mediation process before the advisory committee without any preconditions. The Bavarian state government, as the largest shareholder, also gave a written assurance that Bayerische Landesbank would comply with a recommendation by the advisory committee in any case, even though recommendations in mediation proceedings are normally not binding. A fact which would help Mondex later very much. So as mentioned, Mondex and the heirs started a lawsuit in New York, which to my belief was one important issue to convince the Bavarian government as well as the Bayerische Landesbank to agree to a proceeding before the advisory committee. And therefore, I think it's now time for Geri to explain what happened in New York.
Okay, thank you, Michael. And as Michael indicated, the filing of the lawsuit in New York appeared to really be the catalyst that changed the attitude of the bank. And in fact, the major function of the lawsuit was in the end was its filing. Now, why did we bring the claim in the US? And there's several advantages to bringing a claim in the US. The first one is what we just alluded to, is everything about it is public. And the minute we filed the complaint, and through a lot of the media contacts that Mondex has, there were major newspaper articles, including a major spread in the Munich papers that went over in detail all of the allegations in the complaint. And the complaint contained very detailed allegations telling the whole story that Waldemar started with. But why? So part of it had to do a lot with promoting a change in the public opinion. But I wanted to give you a little bit of background as to why what the advantages are to bringing a claim are in the United States over hearing these claims in the jurisdictions where the paintings may be located in the European courts. And it may well have been these advantages that and the recognition of the US lawyers of the bank of what it means to have a lawsuit like this in a federal court in New York. First, one advantage to bringing this lawsuit in New York is the availability of discovery. The US courts, both the state courts and the federal courts, generally require very broad disclosure. You can get information, documents, testimony from parties, from non-parties, of anything that is relevant to the prosecution or defense of the action, or even anything that could lead to the discovery of admissible evidence. So that is a very powerful tool in bringing an action in the U.S. court. The second big advantage to bringing a case in New York is that there are both federal and state laws and policies that have removed some of the procedural barriers that would have allowed the case to have been heard on the merits, even though it might have been barred in the European jurisdictions on a number of procedural grounds. One of the key statutes that was passed in 2016 that allowed this was called the HERE Act, and it essentially removed the bar of the statute of limitations, which has been an enormous bar in the European litigations to these cases proceeding. And effectively, it said, in recognition of the U.S. policy to ensure that cases relating to Nazi looted art are based on the merits of the claim. They said that any state statute of limitations is void, and in fact has to conform with the limitations period the statute set forth, which would be from the no later than 6 years after the actual discovery by the claimant or their agent of the identity and location of the artwork or property, and a possessory interest of the claimant in the artwork or property. As this is a federal law, it applies to all states. Now, so that's the procedural aspect. The third huge advantage in the US courts over a lot of the European law is the substantive law itself. Now, that can vary depending upon where the case is brought in the US, but I will speak to why that is so significant in New York. And that is because New York substantive law, which would have applied here, is very favorable for victims to recover stolen art. It's favorable because under New York law, a thief cannot pass title, and there is no good faith defense. So that means that under New York law, absent other considerations, artwork that was stolen during World War II still belongs to the original owner, even if there were several other owners afterwards, and even if each one of these buyers said, well, I didn't know I was buying stolen goods. And one of the New York law effectuates this rule is they also have their own statute of limitations, which is sometimes may even be broader than the one that the federal government has passed. And it says that the statute does not even run until the claimant has made a demand on the possessor to return it, and the possessor has to refuse it. And even in that case, under New York law, the burden of proof to prove that is on the possessor to prove that the painting was not stolen, not on the original owner to prove that that it was. So because these rules contrast so significantly with some of the European laws, which even US courts have said place enormous and sometimes even insurmountable burdens on victims from recovering stolen art. Those are some of the key reasons why bringing the lawsuit in New York was so powerful. Now, there's not necessarily a guarantee that US courts will always apply the US or New York law. There are very complex conflicts of law analyses that sometimes the courts go through, but particularly in New York, the courts have found that in line with not wanting New York to become a marketplace for stolen goods, they've been tending to find that New York law should apply. And so that was the very powerful reasons as to why we brought it there. Why were we able to bring it here? That's itself is also a very complex question. And you can only bring here, the paintings were in Europe, the defendants were in Europe, two of the plaintiffs were American, but jurisdiction in the US depends upon where the defendant is. And under the US Constitution, you have to have a certain minimum contacts with the jurisdiction in order to be able to bring that. You have to prove that the defendant has certain minimum contacts with the jurisdiction in order to bring a lawsuit against that defendant there. In this case, it was even, and those contexts can be that they're doing business, that they've transacted business in the jurisdiction, they've committed a tortious act within the state. But in this case, it was even more complex because the defendant was essentially owned by the German government, which made it a governmental entity. And typically in the US, there would be sovereign immunity against such a claim. So we had, and there is a federal statute which sets forth what the criteria are to try to overcome that, that sovereign immunity. And in this case, the complaint listed in detail the basis for that exception, and the exception is twofold. One is it has to be a taking in violation of international law. It's under the Federal Sovereign Immunities Act, and it's called the expropriation exception. And that's one thing you have to prove. But even if you can prove that, you then have to prove that the defendant, in this case, the bank, engaged in commercial activity in New York generally, or engaged in commercial activity in connection with the paintings. And we spent a good part of the complaint alleging details for as to why that was the case, how they had a branch in Manhattan, they had been there for over 30 years, how they used that branch in Manhattan, and how important it was to its German customers, and that they had an art collection, which they used in furtherance of commercial activity, and in fact had loaned this particular painting to the Guggenheim in 2009 and 2010. And we went through great details as to what they did in connection with that exhibition in New York, and how that was used to generate funds and commercial activity in New York. Now, once we filed the case, the next thing that happened is we had a conference before the judge, and that was it was in between those times that Michael referred to that the bank decided, well, maybe we should try to mediate this case in Germany. And so our job at that point was to call a halt temporarily to the lawsuit. They wanted us to dismiss the lawsuit initially and then go mediate. And then, if it didn't work, we could come back. Well, we weren't prepared to do that. So the procedure that we used was we went to the judge and we said, listen, we want to engage in mediation, which is very common in New York courts. But this mediation we want to engage in is in Germany, and it could take some time. And so we entered into a stipulation, and the court endorsed the stipulation and stayed the case so that nothing would proceed in the case until the mediation in Germany was completed. Now that was something that we had to renew every few months because the US courts were not used to mediations that took 5 years. And so the court did each time along, and it is still in fact stayed because we haven't finalized everything yet. And so that was how it moved forward. Now, I will add that in the interim, the Supreme Court has limited the violation of international law definition in the expropriation exception, and it may well be much more difficult to bring these kinds of cases against governmental entities in the US, depending upon the facts. Now, we had enough, essentially what the court held is that it has to be a violation of international law, and it's not a violation of international law for a government to expropriate something from its own citizens. So there then became a number of subsidiary issues. Well, it is a violation of international law if the people from whom the painting was expropriated were citizens from a different country. Well, we had a possibility that we could argue that. We also proposed that there were several takings in this case because there were several governmental entities involved. The first one was when it was taken in Amsterdam. And then we also alleged that there were separate takings when the German bank bought it from the Amsterdam Museum. And so we had a lot of, there would be a lot of basis for us to argue that, notwithstanding this change in law, that we still had jurisdiction, but during the course of the mediation, all of that got a little more complex. So while the U.S. Has great advantages when you want to when you get to the merits of the case, it can be a very long, drawn out process because defendants have a lot of the ability to bring motions to try to avoid that, notwithstanding all the efforts that have been made to try to allow an easier path for these cases to be heard on the merits. So so in the end, that's where we are. The case is still stayed. And it will, once everything is resolved, then it will have served its purpose and contributed to this victory.
Thank you, Jerry. Michael, was there any other point that you wanted to make before we open the floor to questions?
Yes, there are several points which Waldemar asked me to reveal on. After all parties had agreed to go to the advisory committee, we have handed in end of March 2020 the application for this mediation proceeding. The application comprised 460 pages and more than 500 attachments. The volume of this application was essential also due to the fact that with the exception of the acquisition of the painting by Bayerische Landesbank, the entire facts of the case took place in the Netherlands. Dutch, US, and Portuguese inheritance law was applicable, and the Dutch Restitution Committee, in a decision of October 2018, had already spoken out against restitution in the Dutch proceeding of the Bild mit Häusern. So in the following, Bayerische Landesbank denied everything on anything, tried to twist the history of the persecution in the Netherlands, and furthermore made massive and completely absurd accusation against the Lewenstein heirs. In addition, the Rechtsbank in Amsterdam dismissed a complaint against the decision of the DRC in a ruling dated December 16, 2020. Bayerische Landesbank relied extensively on these two Dutch decisions, claiming that the Dutch authorities were the more relevant and thus more competent organization than the German advisory committee. As a consequence, the Lewenstein heirs had to file an extensive replication with more than 650 pages and a lot of more attachment. After the exchange of further pleading, the oral hearing before the advisory committee took place on March 1st, 2023. By decision of 16th May 2023, the advisory committee then recommended that the painting des Bunte Leben has to be handed over or should be handed over to the Lewenstein heirs. Overall, we had to deal with Dutch, US, Portuguese inheritance law, with Dutch family and divorce law from 1940, with German occupation law, with Dutch government in exile law, martial law and allied law measures, with German as well as Dutch restitution law, and so on. This was quite a lot of work, and it was necessary a tremendous engagement by Mondex to find all these proofs, because before the German Restitution Committee, nobody is forced to provide any documents. So it's much tougher than a US proceeding.
Thank you, Michael. Thank you very much. So I think we can open the floor to any, sorry.
Restitution. How the restitution was finalized.
I'm sorry. Sorry, Michael, you wanted to say another point there?
Because Michael, of course, how did we at the end succeed? That's what I think.
Sorry?
How did we succeed?
I think we can explain that. Yeah, Michael, we're good. Thank you very much. We can open the floor to questions now, because we have to keep an eye on the clock, and we can probably cover some of those points in response. So Michael, thank you. Jerry and Axel, thank you very much. And we open the floor to any questions that you may have of any of us.
I have a couple just from online.
Yes.
So what inspired you specifically to work in this legal area?
Is that question to everybody?
Yeah, anyone on the panel, yeah.
Okay. Well, from my perspective, I wanted to find some work that had meaning, that was important. I think we all like challenges, so this is very challenging work. It's very complex work, as you might get a sense of. You know, we're dealing with, you know, complex legal issues over 8 decades in several different countries, and sometimes they conflict with each other. So it becomes very interesting. So I guess meaningful work and interesting work, and I'll open that question to everyone else, really. Go ahead. Waldemar, do you want to say anything about that, or Camila? Or?
I think that when the Washington principles were established, we felt that we could contribute in this area. Although, as I mentioned, perhaps a little bit naively so at that time. But yes, it's really rewarding to be able to work on something that we feel brings change and helps our clients tremendously. And we do get very involved emotionally with all of the cases that we work on. So to be able to work on something for such a long period of time, because often cases take 5 to 10 years, you really do need to feel the commitment and emotional connection to your work, and it really is extremely rewarding at the end of the day. So I don't think we could be more grateful to be able to work in this area.
Thank you, Camila. I was also going to open up the same question to Jerry, Michael, and Axel, but I just wanted to say that one of the things, and probably the most important in response to that question, is we saw a need for people that were trying to resolve these claims, and it's incredibly difficult. I mean, it really is. We're really fortunate. We have a very high success rate. That's because we have an amazing team and we just keep going. You know, we just really, to some extent, we're incessant. So that's very helpful. We're also have an amazing legal team. Geri, did you want to comment in response to that question? I thought you might have a comment or two.
I would like, I would echo what you said, James, but it is a fascinating combination of somewhat esoteric legal concepts, difficult legal concepts, history, and the ability to help people that have been unable to obtain justice for many, many years. I mean, one of the things that makes my piece of this possible is the unbelievable research team that Mondex has. I mean, each of these complaints have pages and pages of detailed documentary proof that establishes the claim. And in a claim like this, that is absolutely essential. I mean, one of the things that has always struck me about this case in particular is that it is the details of what you could find. I mean, the researchers actually found when the Waldemar was talking about somebody coming to the Dutch Museum to pick up the painting in I think it was 1940. And he found, or someone found, I think it was Waldemar who found the business card that was handed in, but it was handed to the museum from the person who had come to pick it up. And then from there you could do all of the proof, but the details, it's these little tiny details that tell the story, that make the story come alive and that help you to prove it. And that's, you know, it's so important and it's fascinating.
Thank you, Geri. Michael, did you want to add anything to that?
No, I'm perfectly well with what Geri said. It's a tremendous workload for Mondex, for your research team. And in some way, all attorneys have to learn that history is still a very important part of their lives.
Thank you, Michael. And Axel, did you want to add anything to that?
Yes, sure, because what I mentioned before, you know, I was triggered by the fact that you tried to engage me as a juror in the Netherlands, which is quite a difficult situation there, also at that time. And the second one was when in our office, we discussed it, you know, if we should take the case, and people said, you have no chance. And that was triggered always my whole life as a lawyer was, if somebody says you never have a chance, I go for it. And that was with the Srebrenica case also the case. And we succeeded here too. And everybody said you have no chance against the City of Amsterdam and the museum. That was where we started.
Thank you, Axel. I should also point out, like on a human level, it was really nice to connect with the family and share moments where they're crying and where they're opening up about their moments. And, you know, if you can put yourself in their shoes for a minute, you know, here's a family that suffered greatly financially, and certainly many of them paid with their lives. They were tortured, they were, you know, suffered on so many levels, and it goes down through the generations, and they feel this angst and guilt and remorse and so many different emotions. And then you come to them with this possibility that we can get you some element of justice. And that's incredible. And when we have the opportunity to do that, it's as fulfilling for us as it is for them. So it feels wonderful. Thank you for asking. Yes, please.
So how did the case resolve in the various courts? And I'm also curious where the proceedings are today and how it happens after the win.
It's your opportunity to answer that question.
Oh, that's correct.
That's my question.
Yeah.
Well, the case in Germany, we just recently completed an agreement, a formal agreement, and there's still some steps to go through with that process. The case in the Netherlands that was resolved just a year ago. And during all this time, we're dealing with COVID as everybody else was, and traveling all over and doing all these things. Yeah, so it's still in the process now of being resolved, but formally, both paintings have now had formal agreements and so on. Thank you. Any other questions? Yes.
Thank you very much for the informative lecture. My question is related to restituting Chinese arts. So during World War I and World War II, large amount of Chinese artworks were looted and spread all over the world. Till this day, most of them still are owned by public, private institutions and individuals. So I'm wondering, what is the most important legal advice you would give for successfully restituting Chinese artworks and returning to the state? Thank you.
That's a good question. I mean, from my point of view, we're dealing with the Second World War sort of framework. So that would exclude the First World War thefts. Does anyone from the legal team want to address any of that question? Jerry saying no, Michael or Axel?
I can,
Go ahead.
but I think it could be a little bit comparable to now the situation for colonial art. So you see now that some countries, like for instance now the Netherlands, Germany, France, actually France started it, making decisions that colonial art has to be restituted and has to be returned to their original countries. But yeah, it's clear that these are also political decisions. So it seems like what we've been dealing at it, if you need somebody in a specific country, in a specific position, and having a specific agenda, who thinks this is important and wants to make some changes. And it could be sometimes like this with the colonial art was really like a domino effect. Like first you had France who made, the first decision, we're gonna restitute colonial art. And then the Netherlands and Germany followed quickly after that. And like the British were like quiet. It was, well, you have the British Museum and that would be a little bit sad place, after committing something to something like that. So I think that there has to be some kind of commitment, or also I think it has to become more known what the issue is, what the problem is, and why these objects need to be restituted. So you need somebody to advocate that. I think. That's,
I think you need an organized effort, and so someone has to step forward and do it. Perhaps like you.
Because for instance, I didn't really know about until you start speaking about this issue that there is this issue. So it has to be more commonly known, and then maybe people start acting on it.
Thank you. Yes.
My question is actually related to Emma's question. To what extent do you see your success in this case to be replicable in other restitution claims, especially claims that whose provenance doesn't start with a private collector, for example, colonial art, or claims that works whose provenance started with a state collector? And do you see your company devoting research efforts or advocacy efforts to restitution of works that are non-European in the future?
We've touched on the idea of pursuing colonial art, but the reality is we're still very busy with art that was made in Europe in the Second World War. What was the second part of your question?
Do you see yourselves devoting resources to doing research and advocacy in other areas of restitution?
I don't think so for the short to midterm. I don't see it's possible in the future, but we're very busy as it now stands and replicating success. I'm really proud to say that our success rate is about 98% right now. So once we make a claim, it's quite likely we'll get something back. And that's typically by working with a great legal team and by having done the research. So as Axel alluded to before, There's different elements involved. There's legal elements, there's media relations, there's political issues. And, there's all these different, moving pieces. So we have a certain flexibility that we bring and adapt to each case. But we also, for example, refuse cases if the claimant comes to us. And this is a little different than what a typical lawyer would do. If a claimant comes to us and says, here's my case, and will you take it on? If we review it and analyze the evidence and it doesn't support the claim, we'll say no. We won't take your case. So I hope that helps you with your answer.
But I think to add to what you were saying is that the work that we're currently doing and advocating for restitution of the spoiled art during the Nazi era encourages people who have interest in restitution in colonial era art, or perhaps Chinese, to see that there is a way. It's obviously a very long-term investment and into gaining and the expertise in this area and advocating and developing these channels to have impact. But I believe that there is some kind of formula that they can follow and have similar success in the area of either colonial or Chinese restitution.
It's doable, so
Yeah.
you just have to make the time and the effort. And a lot of effort. Any other questions? Okay. Jerry, Michael, Axel, is there anything else you want to say before we say goodbye?
No, I don't have any comments. It's nice to be here.
Axel, Jerry, Michael, thank you once again for all your help. And I'm sure that we'll be speaking again soon on many other related issues that we have going.
Yes, and from the perspective of UT Faculty of Law, thank you so much for our panelists today for this really informative session. Thanks everyone for attending.